This podcast is brought to you by the School of Advanced Study, University of London.
Thanks very much. I have to confess, I felt I forced Peter into this. He sent me his program and the late Simon Roberts was still on it, and I said, I'm really sorry that Simon is gone. And then I said, Peter, I need to be the youngest person in the room, and this looks like the only time I'll ever get to be the youngest person in the room again at a conference of what happened in colonial law. Anyway, to be serious for a moment, thank you very much for those wonderful papers. One of the things that struck me, and has struck me over a period of time, is whatever happened to the repugnancy clause. And so I think actually Theo's paper spoke a little bit about the repugnancy clause, except what has happened post-colonial is the construction of repugnancy has changed. So during British colonial times, repugnancy was that which was offensive to British justice and morality and good conscience. And Claire Pally has argued in her 1965 book on constitutionalism that actually those things were not necessarily always negative. So it was about pledging of girls into early marriage, and those were the things that were targeted. But I think it's also fair for us to admit that the repugnancy clause was targeted largely at customary law. And one of the things that's been interesting in terms of the transition from colonialism to post-colonialism is, I think, identified in the paper on Aboriginal rights and the idea that Aboriginal people should have land rights, should have recognition. And I think this has taken off in a very big way in terms of Indigenous rights movements, in terms of human rights claims that are legitimate and I think are trying to be honoured. I thought what was interesting about Tia's paper was this construction of gender. And it seems to me that gender is no longer problematic in the Commonwealth if one defines gender very narrowly, which is what many states seek to do, which is to define it as men and women. So if it's about equality between the sexes, I think there is no contest. So there are loads of cases, especially on the African continent and actually also Nepal, the Dungana case in inheritance. What is more problematic, I think, is a more contextual approach to gender, and I suppose one that takes in what they now call intersections. So intersections of issues of orientation, which you've talked about, but also issues of intersexuality. So there's a Kenyan case from about 3 years ago called RM, and RM is he was intersex. He, and I say he because his mother labeled him male, was born with both sexual organs. Couldn't get a passport because the Birth Registration Act says choose, are you male or are you female? And clearly he was both, he and she was both. And so basically couldn't get a job, couldn't get an ID, couldn't get into school, and landed up being an armed robber and put in a male prison. When a claim was brought before the Court of Appeal saying that they had been discriminated against on grounds of sex, the Court of Appeal said no, there could not be discrimination on grounds of sex because the person had the option to choose to be male or female. And the answer is you cannot choose to be male or female when you inhabit both characteristics. And so the person couldn't, there was no freedom of movement because without a birth certificate you can't get a passport. There was no right to marry because without consummation marriage doesn't exist in Kenyan law. And so this is a form of a construction of repugnance, of only a narrow understanding of gender, which I think is fairly problematic, and we need to think about gender as moving beyond sexual orientation. I think in terms of repugnance, the last thing I want to say, picking up on this, and I suppose it's to challenge, it's my job, I think, to be a little controversial. I'm usually on your side, but I think it's my job to be a little controversial, is to say there is a risk of human rights being constructed by those who hold dear their norms, their values, their religions as the new repugnance. Meaning that David Cameron going to the Commonwealth Heads of Government meeting in Canberra and saying, if you don't change your laws to decriminalise homosexuality, you're not going to get our money, actually resulted in the riposte, which was, we'll keep your money. And I thought a more sensitive approach might be the Hillary Clinton approach when she spoke to the United Nations Human Rights Council. And what she did was to own homophobia as something that has happened in all societies, that people have now recognized that human rights mean all people need to be treated fairly and equally. And therefore we give people rights not because we agree with them, but because they're human. And it seems to me that that may be a better way into talking about plural gender identities So thank you again, Peter, for having me. And as we say in Shona, know where you have come from, for tomorrow there is darkness. And so in tribute to Patrick McCausland, Simon Roberts, and Eugene Cotran, we bid you farewell.